Hello, I'm David DeWolf and I'm a candidate for position 1 on the state Supreme Court. This is the second of 4 videos that explain what is at stake in this election, a choice between a court that respects your rights and one that has replaced your rights with its own idea of how you should live. In the last video, I explained how our state constitution was written to protect and maintain individual rights. That's the very first sentence in Article 1, Section 1. But our Washington Supreme Court in the McCleary case turned that understanding upside down. It thinks that our most important right comes from the government, not that government is there to protect and maintain our rights. In this video, I explain, in the court's own words, how the court understands its role. But before I delve into the details, I want to assure you that I'm not picking something out of context or exaggerating some obscure moment when the court was having a bad day. Instead, this is not only this court's most important case, it's the most important case the Supreme Court has decided in our lifetime. The court itself thinks so. On the Washington Supreme Court's homepage, there are a lot of links, but there's only one case that they highlight. It's McCleary v. State. This is their signature opinion. It's been pending in the Washington Supreme Court since 2010. Since 2012, it's been in the headlines of our newspapers because the court has taken an unprecedented step of holding the state in contempt. Let me repeat that. The Washington State Supreme Court has held the state, the entire government, of which presumably the court itself is a part, in contempt. This is a big deal by anybody's reckoning. So they can be expected to have taken this case very, very seriously. And so should you. The court claims it is just fulfilling its duty to interpret and apply the Constitution, and that those of us who are critical of the opinion are just sore losers who don't want to live by our Constitution. But I hope this video series makes clear that the McCleary Court did not interpret the Constitution correctly. In fact, it's hard to imagine a bigger failure. One of the central principles of interpreting any agreement, whether it's a constitution or a landlord-tenant contract, is to read the agreement as a whole, looking for the party's intent and avoiding any interpretation that would lead to an absurd result. Well, it's precisely an absurd result that the McCleary Court wound up with. Let's review the bidding. The McCleary Court claimed to find in our state constitution what it calls a positive right that is not only different from all the other rights guaranteed in our Constitution, but actually takes precedence over those other rights. Remember the beginning of our state constitution, declaring that the purpose of government was to protect and maintain our individual rights? Well, our current Supreme Court tells us that these rights, our freedom of religion and speech, our right to bear arms in self-defense, and so forth, these are just negative rights. They only forbid the government from doing things. In addition, those negative rights are conditional. If the government has a compelling reason for violating them, they can. By contrast, says the court, our state constitution created a positive right, what they call a true right, the right they claim to have the state make ample provision for education. Not only is that positive right unlimited, says the court, but by using the word paramount, our Constitution supposedly made it superior to all the others. But we're not done. This paramount right, the one superior to all the others, operates in a way unlike those other negative rights, the ones listed in that opening section of our state constitution, the Declaration of Rights. This positive right to an amply funded education doesn't restrain the government, it actually requires the government to act. So how does this work? Well, if there's a positive right that allows me to force the government to act, guess who sits at the controls? The judiciary. After all, aren't they in charge of enforcing our rights? Well, sort of. Let's go back to the beginning of this video series. Our state constitution grants powers to the government on condition that they stay within the boundaries we set for them. We turn to the courts to protect us when our government threatens to take more power than we agreed to give them in the Constitution. We want the Constitution to be a leash on a government, preventing it from running amok. But in McCleary, it turns out, the courts switched sides. It's no longer putting a restraint on government, it's putting government on steroids. It's giving us more government than we want. In the guise of giving us a right, it's actually taking away our most important right and the very purpose of our Constitution, which is to protect and maintain the rights listed in Article 1. In order to enforce this supposed right, this paramount right, this positive right the court claims to have found in the Constitution, the court claims the power to do whatever is necessary to enforce it. Does it mean higher taxes? Does it mean taking money from other government programs we thought were more important? Tough luck. That's what our Constitution requires, or so this court would have you believe. Now, you could say this with a straight face if you had clear evidence that when our state's founders established the Constitution, they signed up for this kind of control by the courts. But we have no evidence of that. In fact, if this were what our state's founders thought they were doing in the Constitution, they would have turned all the rights in Article 1, Section 1 into empty promises. As I said before, you need to read any contract or constitution as a whole and avoid an interpretation that would produce an absurd result. If you suggest that our state constitution set up a legislature and a governor to decide how much we should be taxed and how our tax money should be spent, but at the same time, they wanted our courts to have the power to reject the budget and substitute their own plan for spending, you're suggesting an absurdity. But wait, it gets worse. This power that the court claimed in McCleary is backed up by the ultimate power of a court to hold you or me in contempt. That's the subject of my next video, Part 3, The Court That Lost Its Balance. I hope you'll log on to my website, DeWolfforJustice.org, and watch. Again, I'm David DeWolf. I'm a candidate for the Washington Supreme Court, and I thank you for taking the time to learn about what we can do to preserve our constitutional form of government. Thanks for watching.